How can you add a home to a living trust without having to refinance it? My name is Michael Pevney. I am an estate planning lawyer in California. I create estate plans for California homeowners. Much of this information will also apply to people outside of California because some of this actually has to do with federal law that we're going to find out a little bit. So how do you add a home to a trust and that home has a mortgage on it? What happens to the mortgage? First, you got to make sure that you have a trust. And how do you set up a trust? Biased opinion here, not a big fan of DIY solutions. Best idea is always to go to a qualified estate planning lawyer in your area and in your state that does this primarily, maybe in addition to some other similar areas of law like probate, trust administration, maybe business law, that sort of thing. Sometimes we don't want to go to a complete practitioner that does 50 different practices of law. Someone that really focuses in estate planning is often the best thing to do. But before we put a home into a trust, the trust has to exist. So now the trust exists. But remember, a trust only controls property that is inside of the trust. So if a home is not inside of a trust and it's still in your name or your name and a spouse's name owned jointly, the trust doesn't control what happens to that home, which means that we have to draft up a deed and place the home inside of a trust. Sometimes we do a grant deed, sometimes we do a quitclaim deed. There's a small difference between what the two are. If you have any questions about this, by the way, or anything else related to estate planning, you can ask an estate planning question in the comments. I will get back to them as best I can. Sometimes I will even answer a question by video. So we draft up a deed placing the home from your name as an individual or you and your spouse's name as individuals to the trust with you or you and your spouse as the trustees. This means that you have complete control of the home still and everything inside it. But what happens to the mortgage? There is a small difference between whether the home is your primary residence and whether the home is either a rental property or a home for family or maybe a vacation home. First, if it is your primary residence and we're placing it into a living trust, the government has told us, the federal government, by a law passed in 1982 called the Garn-St Germain Act, nothing can happen to your mortgage. The terms stay the same as long as the people that control the trust are the same people that set the plan and are the same people that are the current owners of the home. So nothing happens to your mortgage if that happens, which is a very good thing. We don't necessarily transfer the mortgage itself into the trust. You're still going to be personally liable for that mortgage. That's not going to get you out of paying the mortgage, and it's not going to necessarily protect that home from creditors or predators. There are other effective ways for doing that. Again, ask a question in the comments or let us know your experience about doing this. So we draft up a deed placing the home in the trust. That deed must be filed in the county where the home exists. So in California, there are 58 counties. Some are very large. Los Angeles County has like 8 million people in it or more. Some counties have like 10,000 people in it. Very few amounts of people. Some states like Texas, there are like 250 counties in Texas, and some of them only have a couple thousand people in it. But either way, the deed must be filed in the county where the property is. We want to make sure all the paperwork is done properly, the deed is worded properly, and most importantly, there is a description of the property and the deed is accepted for filing. A problem that I run across many times is that, especially with a do-it-yourself estate plan and somebody sets up a trust, maybe it's an okay written trust, but probably not the best, but people don't go to that next step of funding the trust, meaning putting things in the trust, meaning actually filing a deed properly written and filing it with the county recorder's office, the county land office. In California, we call it the clerk recorder's office. And oftentimes that means that that home has not actually made it into the trust. So we need to find the appropriate county office to file that deed. We file that deed. If it is accepted and recorded, now the home is inside of the trust and it has to follow the terms of the trust. Look at many other videos that I've created about why it's essential to have a living trust and why anybody that owns real estate in California should have one. So we need to make sure that that home gets into the trust. Now, That's talking about primary residences and homes with mortgages. No change on the mortgage if we are putting our primary residence into the trust with a mortgage on it. But what happens if we're putting a rental property into a trust or a vacation home into a trust and that home has a mortgage on it? Oftentimes, there will be terms in that mortgage agreement, which is an agreement for you to pay, which is a secured loan, meaning that they can foreclose on the house if you don't pay, with what is sometimes known as a due on sale clause. Now, again, for primary homes, this is typically unenforceable, but it may be enforceable with especially a rental property. In my practice, the best thing and the safest thing to do is to call up the bank and to let them know that you intend to put this home inside of a living trust. I want to make sure that my mortgage stays the same. Now, they may want to see a copy of the trust document itself, but in my experience, rarely, if ever, has a due on sale clause been executed and tried to be enforced. Because generally, banks, in my experience, are going to take money from whoever's paying the mortgage. And as long as that mortgage is being paid on time, there's not going to be too many problems with that. I have put hundreds of rental homes into trusts, and I don't believe any of them have ever exercised any sort of due on sale clause, even though it's in there in the fine print in the actual mortgage document. But best practice is to let them know that you intend on putting the home into a trust and you want to make sure that the mortgage terms are going to stay the same. So that is how we put a home into a trust that has a mortgage on it. First, we have to have a trust. Second, we have to file a deed in the county and the state, of course, where that home exists. And yes, you can put an out-of-state property into a trust that was created in another state. I'm in California. Plenty of people own rental homes out of state: California, Texas, Arizona, Tennessee, Idaho, all these places we've been able to put homes into trusts for. And if we do have a rental home, always going to be a good idea to make sure that the bank is okay with doing that without executing any sort of due on sales clause, which may or may not be in that mortgage written into the many pages of fine print. So if you've got questions about this or anything else related to estate planning, drop a question in the comments. Follow me on whatever platform you're watching this on for more estate planning information. I've got about 1,000 videos or so out there. And if you live in California and you don't have that estate plan set up, you can go to my website, ocestateplanlawyer.com, and set up a time to meet with me for free. And that's only if you don't have an estate plan or you need to update one and you're serious about setting it up. I don't really do Q&A sessions for free. That's what I do social media for, so drop a question in there. I appreciate your time and I appreciate your attention. Thanks.